My name is Jay Mann with the law firm of Jennings, Strouss Salmon. What I will be talking about today are the legal pitfalls of guaranteeing bonds for another contractor. Here's the situation. You're a fairly large contractor, you have bonding capacity, you can get bonds to do projects, but there just isn't enough work out there. You can't get all the projects that you want to work on. And you know, a small contractor that somehow has a pipeline to get work. That small contractor may qualify for government programs, may know somebody, for whatever reason, that small contractor can get jobs but can't get bonds. So you, the large contractor, may be tempted to make a deal with the small contractor, guarantee bonds for the small contractor so that the small contractor can get the work, and for that you will be paid a fee. That's the premise. The best advice in this situation is don't do it. Don't walk away from this business deal. But if the temptation is too great and you really want to make that deal, what I'm going to discuss with you are some legal safeguards that will lessen, not reduce the risk, but lessen the risk for you. Before getting started on that, let me explain bonds a little bit. I'm talking about contract bonds for construction projects. These are performance and payment bonds. The bonds are issued typically by insurance companies. They guarantee that the contractor will perform the project and pay his bills. All public projects require bonds, and most large private projects do as well. And here's the problem for the small contractor. The bonds are not easy to get. They must be personally guaranteed, and a lot of small contractors just don't qualify for bonds, so they can't do these big projects. We've gone through a difficult time in the economy. Construction projects are definitely down. Things are getting better, but even good contractors with established bonding lines, meaning that they qualify for bonds, just can't get enough work these days. So that is why the large contractor with the established bonding line will be tempted to enter into what's essentially a joint venture or other business relationship with the small contractor, whereby the large contractor guarantees the bonds, in effect provides the bonding credit so that the small contractor can get the project, which for whatever reason he has the opportunity to work on. There's a lot of risk for the large contractor, and here are some things that the large contractor can do to lessen, not avoid the risk, but lessen the risk. Number one, large contractor should have an active presence at the bonded project. The large contractor may be the primary subcontractor of the project, may be a construction manager, may just have somebody on the project that's out there monitoring. Whatever the large contractor needs to do to keep informed of what's going on at the project, he should do. That way he will have early notice of any problems that are developing at the project. Second, control the funds. You've heard that expression, follow the money. That is really important. More of these deals go bad because the small contractor has taken money from the project and used the money to pay other bills than really any other reason. The best way to ensure that the money that is being paid on this project goes to project obligations is to hire a third-party escrow to be a funds control agent. The funds control agent will charge a fee. It's not too great considering the service that the fund control agent provides. And really, with the funds control agent, there should be no diversion of contract funds. All of the money that's paid on this project should go to project obligations. Very, very important. Third, The large contractor should approve the insurance that the small contractor gets, and really, if it's possible to do so, become an additional insured. Again, when something comes up in the project, the large contractor will know that it's happening and will be in a position to have the money properly used for the purpose for which it's intended, the reason that it's being paid. Fourth, in the event of a default by the small contractor, the large contractor should have the right to take over the project. Extremely important. Presumably, the large contractor has the resources, the expertise, the ability, in the event of default, to step in quickly and reduce the loss that results from the small contractor's default. If things are allowed to fester, if time passes, it always means that the ultimate result will be a bigger project loss, and what will be really a bigger loss for the large contractor that has guaranteed the bonds for this project. Fifth, in the event of a default, the small contractor should personally indemnify the large contractor, and I mean more than just the small contractor guaranteeing against losses by its corporation. Should have the individual owners indemnify, and if it's possible to do so, get some collateral as well. Sixth, use common sense. No matter how profitable a deal may appear to you, large contractor, don't do it if the small contractor is not trustworthy. Don't do business with somebody that you don't trust. Even if you believe the small contractor is trustworthy, trust the small contractor, but verify. It's really important that you keep up with him, keep up with the project, and monitor things as closely as you possibly can. In conclusion, the large contractor needs to understand that under the best of circumstances, guaranteeing bonds for another contractor is a risky deal. Minimize risks as best you can, but be cautious. Many contractors have lost big dollars guaranteeing bonds for unbondable contractors. You have to understand, there's a reason why unbondable contractors can't get bonds. Large contractor, you are taking a risk if you choose to guarantee bonds for the small contractor, but if you're careful, it can work out well for you, and let's face it, provide some work for you at a time when the economy is recovering but still down and work is hard to come by.